Hello and welcome to the RM video channel. I am Robin Meads, a national judge in the UK for sail racing. Today I'm going to be looking at one particular aspect of the new Racing Rules of Sailing 2021-2024, and that is on a redress for injury or damage. The World Sailing Organisation has, in this new rulebook, imposed an additional level of proof required to enable redress to be obtained. It has always been the case that you cannot turn up in a redress hearing and just say that another boat broke a rule and therefore you are entitled to redress. There are other factors that have to be taken into consideration, and these are based on 5 main criteria. So what we're going to do is to look at each of these in turn. Here is a list of the things that have to be proved by the applicant to the satisfaction of the protest committee or jury on the balance of probabilities, which is the new test under Rule 64(1)A. Evidence is usually visual, verbal or documentary, and where appropriate I will give what I think is the weight that would be applied to a particular type of evidence. We can also now accept hearsay evidence in a hearing due to the amendment to Rule 63.6. Although there is a legal definition of hearsay for criminal proceedings, a more general definition, which can be more easily understood, is that it is information given or acquired from another and not part of one's own direct knowledge. The weight to be given to hearsay evidence will depend on what that evidence is and where it comes from. It doesn't mean that just because evidence is given that is hearsay evidence that it will be accepted by a protest committee or jury. It has to be given weight. So item 1 on the list, an applicant boat's score or place has been or may be made significantly worse. What does significant mean? Well, in general, in racing terms, I would have thought it means that if you are in a position where you have lost first, second or third place because of the incident, or have lost a gold medal, etc., because of it, then that is significant because it is sufficiently great or important to be worthy of attention. If, on the other hand, you have lost 3 places when you would only have expected to be 15th or 20th or whatever, then that is not really significant. So you may fail on item 1 before you get any further. Also, this will be looked at on an objective or factual basis and not on the hurt feelings of the applicant, which is the subjective view. Let's have a look at the examples of evidence. Under A, the applicant boat is unable to continue racing. The race committee records of retirement would be good evidence. Also, the skipper of the boat could give evidence to that effect, as shown in B. And again, there would need to be some additional evidence for this, such as written acknowledgement of retirement to be passed to the race committee. If the applicant boat continued racing, how many places did she lose by having to put things right? The evidence would involve looking at a comparison with other races, if possible, from the race committee records, and also the applicant could bring in witnesses from other boats who saw that there was a problem. One thing that is frequently overlooked by applicants is that under 62.1 the loss of place or score must be through no fault of her own, of the applicant boat. So if the applicant boat did not keep a proper lookout, even if on starboard, then the claim for redress will be lost. Also, the applicant boat must not have breached a rule of Part 2 that contributed to the same incident. So if the applicant boat brings a protest and is found to have broken a rule of Part 2, then that will defeat the claim for redress. So although, as we will see later, a protest hearing result is conclusive evidence, it is a two-edged sword. Now we will look at the third criteria, which is injury or physical damage. And first we'll look at injury. It can be any physical injury to the helm or crew, whether minor or major, and so we would need to see a description of the injury, perhaps a photograph, or established by a physical inspection by an independent witness, which would be good evidence, or a witness from the applicant boat, which is relatively weak evidence, or it can be independent confirmation of medical assistance obtained, which is very good evidence. It also needs to be established what the effect of this injury was on the applicant boat's racing ability, because if it didn't have any effect, then any loss of place or score will not be relevant. World Sailing Case 110 establishes that contact between the boats is not necessary. What you have to establish is that the injury to the crew was caused by the incident. So if the applicant boat had to take violent avoiding action and a crew member broke a limb during this manoeuvre, then that would be good evidence of the injury having been caused by the other boat. With regard to physical damage to the applicant's boat or its equipment, the protest committee or jury would need a description of the damage from preferably an independent witness, its effect on the applicant's boat's racing ability, possibly a photograph of the damage, and it would need to be established preferably by an independent witness, which is good evidence, or the applicant boat's witness, which is weak evidence, unless supported by other evidence. Again, case 110 confirms that the applicant boat is only eligible for redress if the damage itself significantly worsens her score or place. Simply having a worse score or place due to an avoiding manoeuvre is not ground for redress. So what is damage? Well, World Sailing Case 19 gives a couple of examples, one of them being if the current market value of any part of the boat or of the boat as a whole is diminished, or if any item of the boat or her equipment is made less functional. These are only two of what could be several examples. For example, if the boat is holed and has to return to port and it makes racing unviable, then that is obviously damage for the purpose. But whatever the damage is, it must affect the ability of the boat to either continue racing or continue racing at the same level that she was racing before the incident. The term damage would of course also include serious damage, and that in particular relates to Rule 44.1b, but World Sailing Case 141 again says that there is no special meaning to serious damage, but again this could include: did the damage reduce the safety of the crew? Did it adversely impact the boat's sailing performance in a significant way? Will the cost of repairing the damage be a significant amount relative to the market value of the boat? And will the value of the boat after repairing the damage be significantly diminished? The fourth critical element is because of or caused by. So we have to look at what caused the damage or injury. And although there are three elements here, two of them do not occur very often comparatively, which are that it involves a vessel not racing that was required to keep clear, or a vessel determined to be at fault under UPCAS or a government right-of-way rule. So we will concentrate on the first element. In this element, the damage or injury must have been because of the action of a boat that was breaking a rule of Part 2. So we have to look at how the applicant boat would establish that causation. And the first and most obvious way to do it is to produce the record of a protest hearing that results in Boat B having been found to be in breach of a rule of Part 2. This would be conclusive evidence. If Boat B was found to have been in breach of a rule of Part 2 but was exonerated, then this will fall into the new addition to the rule that we will look at in a moment. If the applicant boat brings a witness from Boat B who admits that Boat B broke a rule of Part 2 that caused the injury or damage, that is strong evidence, but again it is affected by the new addition to the rule. The applicant boat could bring a witness from another boat who saw the incident, or a witness from the applicant boat, but both of these would be weak or very weak. And why is that? It's because it is very difficult to establish whether or not another boat has broken a rule without having a hearing, as it is all just subjective and a matter of supposition. We now come on to the new addition to the rule introduced in the 2021 to 2024 rulebook. This applies only to the element where the injury or physical damage was caused by the action of a boat that was breaking a rule of Part 2. This additional requirement is that the other boat took an appropriate penalty or was penalized for the incident that caused the injury or physical damage. Again, it is up to the applicant boat to produce the required evidence. So what could that evidence be? This is a bit more complicated and needs some detailed explanation. The first preferred and conclusive evidence is a record of the protest hearing at which the other boat was penalized for breaking a rule of Part 2 that caused the incident. The second possibility is that the other boat retired due to the incident and not for any other unconnected reason. For this, the applicant will need a race committee record as to the retirement and either a record of a protest hearing or arbitration where it is established that the other boat retired due to the incident, which is strong evidence, or a witness or written statement from the other boat that she did retire for that reason. In my view, it is not sufficient just to produce evidence that the other boat retired, because she could have retired for all sorts of other reasons. We also have other forms of penalty under the rules. There could be a scoring penalty or a post-race penalty taken as a result of an arbitration hearing. Or she could have done turns. The problem that the applicant boat has with these other three types of penalty is that a scoring penalty, a post-race penalty, or turns are not an appropriate penalty for injury or serious damage. And for the applicant boat to obtain redress, the other boat must have taken an appropriate penalty or been penalised. So, if there is no physical injury and any damage is not serious, then we can look at the evidence required that the other boat took a scoring penalty, a post-race penalty, or did turns. If we are talking about only, in inverted commas, ordinary damage, then this will have a knock-on effect as to the evidence as to the boat's performance, affecting its score or place. In any event, the evidence for a scoring or post-race penalty could be the race committee record of scoring, which is strong evidence, and either a record of the protest or arbitration hearing where it is established that the other boat took that penalty due to the incident, which is also strong evidence, or it could be a witness or witness statement from the other boat that she took the scoring penalty due to the incident. That is also strong evidence. If, for example, the other boat did turns, then the evidence required is both that she did the turns and that they were connected with the incident. The strongest evidence for this would probably be a witness or a statement from the other boat. You could also have a witness from another boat who saw the incident and the resulting turns. This is medium to weak evidence depending on the link between the incident and the turns. And finally, a witness from the applicant boat who saw the incident and the resulting turns, but this is relatively weak evidence. So, in conclusion, the applicant has to get all his or her ducks in a row and make sure that all of the evidence required to establish the 5 main elements under the new amended Rule 62.1b are available to the protest committee or jury. For what it is worth, my own opinion is that any applicant needs to ensure that they have protested the other boat, even if that boat has retired or taken any sort of penalty. The penalty doesn't matter because the task of the applicant is to establish the facts leading to redress. And even if you have a protest hearing where the other boat cannot be further penalised, that from the applicant's point of view is irrelevant, because what you need to do is have the strongest possible evidence to lead to obtaining redress. In bringing that protest hearing, the applicant boat has to be reasonably confident that they have not broken a rule in connection with the incident and are not otherwise at fault. Also, it would be wise to stand back from the emotional context and just consider whether the loss of score or place is significant. I will just finish with a word on how exoneration affects all this. Under the new Rule 43, it is now up to a boat to determine whether or not she is exonerated, and it is not left to a protest hearing to make that decision. The effect of exoneration is that if a boat has broken a rule of Part 2 and is exonerated, then she has not taken a penalty. So the only way to test whether or not a boat has been correctly exonerated is to bring a protest hearing. Otherwise, the exoneration defeats the claim for redress. So I hope this information has been useful, and if so, please subscribe to my RM video channel and make any comments that you wish on YouTube. Thank you for watching. Bye bye.